May it please the court, my name is Morris. I appear on behalf of the defendant, Ms. Stone, to make a plea in mitigation. Your Honor, under Section 317 of the Criminal Code 1899, the maximum penalty for grievous bodily harm with intent is imprisonment for life. However, I move to suggest that my client does not deserve a life sentence due to the mitigating factors in Section 9 of the PSA. My client is a victim of what Professor Renaud Walker in 1979 described as a battered woman syndrome, BWS. It's a psychological alteration of the mental state suffered mainly by women who are victims of cycles of domestic violence, like in the case of Wallace. This leads to what develops as learned helplessness, described in the cases of Lentini and Wallace. It's therefore common for such victims, if they defend themselves, to tend to strike during a period when their abuser is subdued, drunk, or indisposed. In the case of Shea, this explains why Miss Stone attacked her de facto partner in the early hours of 5th December 2020 when he was sleeping, intoxicated, and unable to physically attack her back, like in the case of Hill. BWS is a feature which weighs very heavily in terms of mitigating a sentence, as decided in the case of Zasenvik, Meuzijak, Ravari in Canada. The Lujanjic and Continen case was the first Australian case to accept expert testimony of BWS according to principles outlined in Transport Pty Ltd against Literature Board. Your Honor, that case confirmed that a psychologist is an expert in the field of BWS because BWS is an attitude of the mind. It's a matter of assessing, not diagnosing a psychological or psychiatric illness. That was the case of Continent. Since then, BWS evidence from psychologists has been used in cases like Clark against Ryan, BLM against RWS, Webb against the Crown, Crown against Worsley, Crown against Singleton, and the Crown against Mackenzie. Your Honor, I therefore implore this court to accept into evidence from the court-appointed psychologist who, even though did not qualify to make mental health diagnosis, pointed out that my client was incapable of making sound moral judgments due to her long life significant circumstances of disadvantage and abuse. Your Honor, it therefore falls upon this court not to give too much emphasis on general deterrence, but psychological explanation of her actions. That was in the case of Scott against SA Police. She survived a dysfunctional and abusive childhood. She has been an alcoholic. She has been through frequent episodes of emotional and physical abuse inflicted by the grab, the plaintiff. As a result, she suffered a slow burn, described by Chief Justice Glinson in the case of Crown against Shea, of fear, despair, and anger, which eventually erupted on December 5th, 2020. For the 3 years of abusive and controlling behavior, she built up a dam of self-control that eventually had to burst, as described by Justice Caudry in the case of Bradley. Her decision to take the law in her own hand might, from the outside, look like poor judgment. However, a perception of narrowed options often result into such decisions, as described by Justice McMurdo in the case of Mackenzie. I would now like to direct the court to Section 13 of the PSA that states that court must take the guilty plea into account. Like in the case of Siganto, a plea of guilt indicates some remorse on the part of the offender because the offender has spared the community the expense of contested trial. Your Honor, my client made admissions to the police in relation to the details of the offense, including the premeditation. She indicated a willingness to plead guilty prior to the presentation of the indictment. She has spared the victim and the witnesses and this court from the traumatic procedure of giving evidence and rehashing the distressing details of the night. Her timing of plea of guilt, that is in the case of Thompson, is an intention to plead guilty at an earlier time attracts a larger discount. Miss Stone informed the police of her intention to plead guilty at the earliest opportunity available to her. Your Honor, by doing so, she accepted responsibility for actions and willingly facilitated the justice system that warrants a benefit of discount available. Your Honor, Section 92H and Section 13A, 13B of the PSA specifically list offenders' assistance to the law enforcement as a mitigating factor that must be taken into account when sentencing a violent offender. There's no doubt that my client assisted police in their investigations. She surrendered herself to the police, saving the taxpayer the expenses that would have been incurred when effecting her arrest. Like in the case of Bognovich, where the battered woman, after killing her husband, drove herself to the police and reported the incident. Justice Maxwell in that case found no valid reason for the imposition of the custodial sentence because the woman was in a desperate act of somehow trying to hold on to life. He sentenced her to a non-custodial sentence and a 4-year good behavior. It's therefore imperative that even though my client is less likely to afford any fine because of her being on a disability pension, for her much needed rehabilitation, this court should offer a non-custodial sentence. Your Honor, Section 93G 11B of the PSA requires the court to take into account the offender's previous offending history. The prosecution brief provided to the court indicates that Ms. Stone has no prior convictions or criminal history. Despite possessing a large hunting knife, she has never actually used it illegally. She has no history of violence in her previous relationships, and the compassionate side of her was revealed when she said she never wanted to kill the victim. The growing references from the community she works as a volunteer attest to her good behavior. This incident was clearly an isolated one and completely out of character, just like in the cases of Ryan and Len. Your Honor, the custodial sentence in these circumstances served no useful purpose. Like the case of Bagonovich, these circumstances inevitably attract a very considerable degree of sympathy, and the court always opts for non-custodial sentence. Being a middle-aged woman and currently unemployed, a criminal record will definitely shut down her chances of gainful employment. Therapeutic jurisprudence demands a non-custodial sentence. However, if the court is of the view that the immediate custodial sentence is the only susceptible applicable sentence, I would invite Your Honor to acknowledge those factors I've mentioned before. Those are my submissions, unless I can assist Your Honor any further.